Welcome to my channel. This is a girl Mercy. In this channel I talk about law, practice, I talk about tips for a successful practice. So today I'm going to talk about how to raise objection during trial. When documents are sought to be tendered in court, you as a lawyer, you must know what to say, how to evaluate the document before it is admitted in court. The first thing you need to know is you have to know the nature of the document. When a document is given to you, you need to ask yourself, is this document a photocopy? Is it an original? If it's a photocopy, then was a proper foundation laid? If no proper foundation was laid by the lawyer seeking to tender it, then you need to raise an objection to its admissibility. The next thing you need to also note, you have to ask yourself, was this document front-loaded? Was this document pleaded? In this era of front-loading, all documents in proof of a matter must accompany the originating process. But where a lawyer springs up a document in the middle of trial to tender it, you have to object to that. Because if the document was not front-loaded, it cannot go in. Now, another question you need to ask yourself is, was the document pleaded? If the document was not pleaded, you can raise it as a ground of objection. But you have to have caution with respect to this line of objection, because if there are facts in the witness statement on oath which describe the existence of that document, this objection may fail. The next thing you need to note is you have to ask yourself, the document that is sought to be tendered, is it a public document? If it's a public document, then it has to be the certified true copy. No, nothing less than that can be admitted. If it's not a certified true copy, you have to raise objection to that, in line with the provisions of the Evidence Act. The next line of objection you can raise is, even though the document, being a public document, is certified, you need to now ask or look at whether it was properly certified. Section 104 of the Evidence Act lists how a certification ought to be done. Another thing you need to ask yourself is, this document that is sought to be tendered, is it signed? You know the value of an unsigned document, it is void, it is worthless. When the document is not signed, you can raise that as a ground of objection. The next thing you need to also note you have to check whether the document is a computer-generated evidence. If it's a computer-generated evidence, then it has to comply with Section 84 of the Evidence Act. Where it fails to comply with Section 84, where there's no certificate of authentication, where there are no facts given by the witness as to how the document was produced, then you have to raise objection as to the admissibility based on it being a computer-generated evidence and did not comply with Section 84. So today you've learned tips on grounds you can use as grounds for objection during trial. Because as a lawyer, not just a lawyer, a smart lawyer, you must know these at the tip of your finger. So please, if you have not subscribed to this video, to this channel, subscribe, click the like button, share this video. It will help someone out there. Please watch out for the next video and keep watching. Thank you.